Hi, my name is Maya Atrakchi. I'm in the international group at Jackson Lewis, where we really support our U.S. clients with their global employment law needs. We're part of L&E Global, which is an alliance group made up of 34 firms in over 40 jurisdictions. And we really operate as one firm. We work together on a daily basis. And one of the big areas that we work with and constantly see U.S. companies really navigating the challenges associated with global issues are restructuring and reductions in force. I have my amazing colleague Florence Bacquet here from Paris. She'll share a little bit about herself. Florence and I work regularly on restructurings and reductions in force. And we really see pain points reoccurring for U.S. companies as they are navigating a reduction in force that may impact their U.S. workforce and their workforce more globally. So we hope the discussion today will be very informative. Some key takeaways, misconceptions, risks, best practices that companies can take with them. And we hope you enter your next restructuring or reduction in force more effectively, more efficiently, and most importantly, cost effective. So I'll turn it over to Florence and then we'll jump in.
Hi, thank you, Maya, for this. I'm Florence Bacquet, so I'm a French qualified attorney. I'm with Clichy-Granger, so the French partner of Jackson Lewis in the L&E Global Alliance. And just as Maya explained, I'm working together with Jackson Lewis in several international projects, and especially in restructuring, which I mostly specialize on. And I guess one of the key elements that we see is that Europe, and I'll try to speak as much as possible about Europe as a whole, but Europe youth often feels very complex and very different to the US structure. And this is where it's important that we liaise together. And this is what we actually do with Maya on our day-to-day basis to try and find pragmatic and practical solutions for our clients to navigate this very different environment.
Excellent. Thank you so much, Florence. So you really started, discussing what we've been on working with today. I thought, as a kickoff, what do you see as the biggest misconception of U.S. companies as they're handling a RIF? They start out in the U.S. We're an at-will jurisdiction. They think terminations should be fairly quick. They, decide that they want to terminate, next week, and they would like that synchronized across the globe. So I guess I sort of, tapped into it a bit. But what do you see as the biggest misconceptions that U.S. companies have as they're navigating in France and Europe more globally?
I think the biggest misconception is just that Europe, first, would be like one single jurisdiction and acting just as a whole. And second, it would be just slower than the US. It's not just it is to most often. Let's be honest, but also it's a different kind of perspective on RIFs. It's more process driven, and process is very important in how we see it. It's a very regulated legal process, and that's in the various and most of the jurisdictions over Europe. So it's really not just to give more time, it's also to actually follow the steps. And if I take the example of France, of course, we have a specific process depending on how many restructuring, how many job cuts you have, but it's actually the same in Germany, it's the same in Spain, it's the same in Italy over some certain thresholds. So you have in various jurisdictions a very specific process to follow, and if you don't, this is where you have an issue. So the misconception is just it's not just slower, it's very structured process, and it's not harmonized. I mean, we have directives in the European Union, and it will set the floor, if I can say it like that, but each local jurisdiction has its specificities, and any client would need to be sure that the project is adapted, is compliant with each local jurisdiction and each local law.
Yeah, and I'll really add that, in terms of harmonization, we really see this issue vice versa when companies are entering the United States, and this is actually a podcast that we'll do in a few weeks regarding US restructuring and sort of misconceptions that global companies have. But in terms of harmonization, a company enters the US and they expect the termination to process to be one-to-one, regardless if their employees are in California or in Florida or New York. And high level, of course, it is. But there are all sorts of nuances, the payout of PTO and bonus, notices regarding unemployment benefits, final pay of salary. All those things are both costly and can create compliance and reputational issues if not followed. And I think U.S. company as they're entering the EU, they have sort of an understanding that there are these directives, and they think if they're in France or they're in Belgium, they're in Germany, the process will be quite similar. And we do see expansive differences. Shifting now into sort of a more sort of soft matter. When do you think EU Council or local council in general should be involved in the global RIF process? A lot of times we see clients coming to us, again, as mentioned at the beginning of the podcast, they're notifying employees in the US next week, and they'd like to do a similar process in the EU. What's too soon? What's not soon enough? How do you see that balancing act of, involving local council and at the same time trying to be aware of, global synchronization and not going too much into the local requirements before you need to?
Yeah, it is a balancing act, and I'm not sure there is a too soon. There could be at some point when you have not enough detail and you don't know yet, but clearly too late is going to be the most expensive. I think one key moment, and that would apply to about every jurisdiction in Europe, would be when you have the headcount number per jurisdiction, because it is going to be, and I'm sure we'll have time to talk about that, it's going to be a key element that's going to very much shape the process to be followed in each jurisdiction. Your process is going to be different depending on how many job cuts you have. So once you have the headcount in each jurisdiction, you need to have local council involved to understand whether this is a small restructuring, no restructuring at all, or even if it's a more massive restructuring that you need to anticipate. Second, it's not just to me having the head count and knowing where you go. It's not just about the process. It also helps maybe find alternative solutions. We had this case, and it was in fact in a case with Jackson Lewis, where we had this client wanting to do a very big restructuring all over the world, really, and coming to France, having this tough process that we have for redundancies in France. We were able, because we were early enough, to say, okay, given your numbers, given your headcount, maybe we tried an alternative route which will be more effective for you, and that was through a voluntary plan. And if you're too soon, too close to the actual announcements, you don't have time to, reshape, rethink, take a bit of, just take a moment to think about what's going to be the best way forward. So once you have the numbers of job cuts, the number of, and you have clarity on the headcount in the country, in the jurisdiction, to me, that's the very last moment you need to involve local council to understand what's going to be the compliant route and what could be an alternative yet compliant route to take.
Okay, and tagging on along with that, what triggers a collective redundancy? Of course, in the EU there is this collective redundancy directive, but how countries have implemented this can really vary on a case by case basis.
Yes.
The number of
It,
of terminations over what period, and so what triggers are there in France? What is there to consider globally? How could we, potentially avoid hitting those numbers?
if we talk about France, I'm going to scare people off here, but this is very small. The trigger is if you have just two redundancy, they're small process, but it's fine, really. It's pretty straightforward. But if you reach a 10 and 10 redundancies over the same period of 30 days, and it's not that much, really, you come up with this number very fast. Then you start to have a much bigger process to follow with works council consultation, with social plan, and with many other elements. And in fact, this threshold, so France being 30 days and 10 job cuts, is going to be adapted to each jurisdiction. So this is where it becomes a bit tricky because you don't have the same thresholds. The directive sets a minimum, but it's some countries, including France, including Germany, have lower thresholds. And they also can depend, for instance, in Germany, on the size of the company. So it's not necessarily the same threshold that you will have on bigger companies than on smaller companies. This is also where, as a client and at the foreign company, you need to have local counsel involved and don't just read what you can find on the internet or in some AI chatbots, because yes, it is a very complex matter. It is very different into various jurisdictions. So you need to have someone being able to say, okay, this is your situation. So these are the thresholds actually applicable to you. That's where it becomes key to have this advice.
And what about alternatives to sort of avoid? Do you recommend clients
Yeah.
a voluntary plan, or maybe if they're very close to the threshold number, to think of potential alternatives, potentially even spacing out the termination so as not to fall within this defined period?
Yeah, that was what I was mentioning about, having the council sufficiently in
Yeah,
advance to
yeah,
be able to shift to those process. One thing where it's also interesting to have voluntary plans, for instance, that in Europe mostly, you have what we call selection criteria. You cut jobs and not people. You don't pick and choose the people you want to see gone. It's really about the positions. And that's really about restructuring, about forced redundancies. So when we see clients who will have issues, maybe defining the economic rationale that has to be presented at some point to support the restructuring, a client that will have issues just fitting the right number or going into a very large process, restructuring process with a social plan, with a works council consultation. Whereas given the headcount, given the context and how the workforce is shaped, maybe a voluntary plan, which will lift all those or many of those constraints, will be as efficient. It will be different. It will be presented different. And it will come to another point that we want to make together. That's communication that needs to be harmonized. So the communication is not going to be the same. But in the end, I think what we aim for is to implement the restructuring. Maybe it will be an alternative route and it will be as good. So through voluntary plans. Sometimes we have clients having more time, so maybe we can, anticipate other ways to just work side by side on smaller plans, but on a wider period. So there are alternatives, there are compliant alternatives available, and sometimes they're more fitted to what the company needs, in fact, and what is also going to be able to deliver. Because working through a works council is not necessarily easy. It's not that it's too scary, but shouldn't be too scary. But anyway, the company needs to be ready. So having those alternatives available and having the time also to look at them and to consider them is
sure.
important.
And you've mentioned Works Council a bunch, and that really brings me to
Yeah.
my next question. I think US companies hear Works Council and they just find the concept intimidating. Would love to hear for you, almost on a basic level, what is a Works Council? How is it different than a union? What role does it play in this process? And how can we maximize the relationship with the Works Council to make the process be more smooth and efficient?
Sure. Works council do not exist in every jurisdiction in Europe. I would say it's more Central Europe. For instance, it's not in the UK is no longer part of the EU, but it's not in, I would say, in the Anglo-Saxon countries, not in Ireland. Works council do come rather France, Belgium, Germany, Italy. The idea is that it's an elected staff representation body. So it's people from the company, employees from the company being elected to represent everyone, regardless of their being associated with a union. It's really the people voting, the people talking for the people, if you say. It's a bit like an MP or a House representative. So it's through an election, whereas a union represents, well, a union, and a union member comes from that. And so Works Council, and I understand why it can be intimidating, especially in jurisdictions such as France, Germany, or Belgium, where they have a lot of powers. They can request experts to help them move through the process. So let's be honest, it can be intimidating. Yet, when you have a transparent communication, when you are compliant with the regulation, then in fact, the relationship with the Works Council can be beneficial to everyone. They can also bring out some good elements. What's key to understand, at least for France, and that's not the case in every jurisdiction in Europe, for instance, different in Germany, but for France, the Works Council has to be consulted, that is, to give its opinion, not agree, but just give its opinion on a project before it is definitive. So on this point, it's really very important that the Works Council be informed before you have a big announcement saying it's done, it's over, project's done. In Germany, on the other hand, you can do it sometimes later, but for some projects you need to have an agreement. So again, we come to the same idea that each local jurisdiction has its specificities. But in terms of Works Council, one of my clients told me, you have the unions and the staff reps that you deserve. So if you were transparent, if you work in a transparent way, and you accept that you have staff representation and accept that they can work with you, and that, yes, sometimes they will ask questions and you will need to answer, but they can also bring some ideas and give you some feedback on what the employee think, and it's going to work okay. If you are very confrontational from the beginning, then usually it doesn't work very well at the
Sure.
end.
No, and navigating, you touched on it, but the communication, not just of, what's compliant and what's required, but understanding the cultural nuances of that particular jurisdiction, of the relationship that the company has with the work council in that jurisdiction can go such a long way in helping the process run smoothly. You sort of touched on it in terms of the consultation process that's required with the Works Council, and also more broadly across the EU. In the UK, in Ireland, and outside of Europe, also in Australia, Israel. There's consultation processes. A lot of issues that we run into is that timing and coordination. So, a company will come to us and it will be really important for them to have synchronization. They have departments that work very closely together. So a department, marketing will have an employee in France, and they'll have an employee in Australia, and they'll have an employee in the UK, and they'll want everyone notified at the same time. Also to keep a positive morale of their existing workforce, to say, this termination is occurring now. There won't be any additional ones following this announcement. But there's tension between, an at-will jurisdiction like the U.S., where you can provide notification fairly quickly, versus other jurisdictions. How do you see this tension? How do you see companies navigating and balancing this act of trying to, provide synchronization and also maintain compliance with consultation processes, notice periods, etc.?
Yeah, there's a tension, really. And we have some solutions. They're not always the best solution, because clearly, the timing is very different. And from the US to some countries and Europe, and between countries in Europe, because you could go faster in some countries, and in some other countries, France or Belgium, you need to wait until the Works Council has issued its opinion before you can make some very formal, definitive communication and announcement. So, in fact, we work around it. We try to find solutions who can at least satisfy everyone. And usually what we work with is to say the company announces globally its proposed restructuring, and it insists locally on the fact that there are some country by country consultations, because meaning that the Works Council has to be consulted doesn't mean that you cannot communicate at all. It means that you need to shape your communication so that whatever you say is still a project. It's not the best And I understand because it doesn't allow the employer to just give a very straightforward message. It's, of course, it's a bit different. It's a project, it's proposed, but at least it allows that everyone has the message at the same time because, as you said, you have some people in teams in various countries. Of course, they're going to talk to each other in something that just is being disclosed in the US morning time is known French time afternoon, but at the same, like within seconds, everyone within the team knows about it. So it's really key to coordinate communication in terms of timing, but also in terms of what you say. And we've had some cases where unfortunately, it went up to litigation, and actually, the communication was used by French courts to say, okay, what you communicated to the overall company, to the world, really, showed that you had made up your mind. It was no longer a project, it was a decision. So it's something to be mindful of. It's not because it's just an internal message that it's not going to come up later on to turn against you. So again, what we work with is just to say, to work around terminology, propose restructuring, insist on local consultation, and try to navigate this way, the way like that, to find compromise really between the various constraints. And I have to say, this is why also another reason to involve local counsel, not too late in the process, because it gives us just a bit of time to go through the communication decks and to ensure that this is compliant. And we try, when we review that, to be just as minimal as possible on the edits we suggest.
Another surprise, and one of the key components of this as a company is navigating or restructuring or reduction in force, is severance and cost expectations. Across various jurisdictions, there's statutory redundancy fees, there's different notice periods. You can be required to pay restrictive covenants and strong expectations around enhanced packages. Um, how do you propose a U.S. company think of severance and more generally costs around a redundancy in the employment law space as they're navigating redundancy globally in the EU and France specifically?
I have to say that, to your point, after discovering the works council and being afraid of the works council, the second scary part is indeed severance costs, which are much higher than what you can see in the US. That's a fact, and there is nothing against it. Um, I think there is just the trend in many jurisdictions to make it more transparent and predictable, and that was something France worked a lot on since 2017. I know Spain has a very straightforward formula applicable, but basically, I think the very difference with the US is that it has several layers, if I can put it like that. You have a notice period in most countries. Then you have severance payment, which is either set by the law or the collective agreement that would be applicable. And on top of that, you could have accrued vacation, PTOs that would need to be paid if not taken at the end of the contract. And on top of that, even on top of that, if that's not enough, if you don't follow the right process, or if you cannot demonstrate the right economic rationale, then you come with damages on top. So you can see that you have several structures. It's very important to anticipate those costs and to be conservative, I have to say, about those costs. Well, it's always a nice surprise when in the end it costs you less than what you had expected. Um, but clearly it's a multi-step process, and at least what we can say is that in various countries, because it has been presented by foreign investors as being negative for the business and not business friendly, because it was unpredictable how much you could get, how much you would have to pay when hiring someone, then there has been significant work to try to make it more predictable. Again, Spain has done it. In France, we have done it, because now the amount can be defined beforehand because we have those branch collective agreements, but also in terms of damages in court where we have a scale of damages with the maximum. That's very helpful in terms of navigating your cost and knowing where you step, in fact.
Yeah, we really emphasize to clients the importance of budgeting. In some cases, maybe creating a best case scenario, worst case scenario, and then something in between, managing expectations for leadership. Even if things generally run as planned, you have outliers, employees that are on sick leave and maternity leave and disability. And each situation needs to be navigated accordingly. And so, the more a company can be flexible and adaptive and understand what the ranges and expectations, the process goes smoothly. And I think people long term have a better expectation versus going into new and their next restructuring, and also the workforce more broadly sees the transparency. Just to finish up here, I thought maybe we'd go through some best practices. I mean, I think we've touched on a bunch of them throughout our discussion. I'll kick off one actually that we didn't speak with so much, but something that I see really as a differentiator for reductions in force and restructuring that go more smoothly than others, is the alignment between various departments: legal, HR, finance, communications, your broader leadership team. When a process is siloed, so like let's say only HR is handling the process, or only legal is handling it, and there isn't this alignment and transparency between the departments, things can fall through the cracks, and it can also impact your reputation with your employees more broadly. We have in certain processes, we'll do a daily call where there's a representative from each department, maybe one or two representatives. I mean, you don't need too many cooks in the kitchen, but if there are various regions involved. And this is something simple, but can go a long way in ensuring that the process is efficient and effective and compliant. Of course, budgeting we spoke about. Anything else that comes to mind for you in terms of best practices?
I'd say, and just to give something more on what you said, it also helps when it comes to consultation or to involvement of staff representatives in Europe. It gives everyone a better understanding of what's really the operational constraints and why we are asking those questions and why we need to answer. So I think it gives to everyone a better background and a better information. I'd say, so you mentioned alignment and all for it. I would say also it's important to go fast, but sometimes too fast is not good. It's not good either. So it's not always about being fast. It's also about sometimes knowing when to take the time to do it right. Because when you start a process too fast and you've not done your business right, then it's going to fail, and that's going to be time lost in the end because you have to redo it all over again or reputational damage. And I would say, if possible, and I'm conscious and I'm aware that it's not always possible, but having an HR operational in your jurisdiction, in your foreign jurisdiction, in Europe somewhere, or someone closer to those jurisdiction will be having some boots on the ground at some point. Someone who will be able to actually negotiate with the unions or the works council if it comes to that, or who actually knows about the teams and their organization and how the RIF is going to impact them. Because when the process is just managed from too far away, then sometimes you do in fact miss the small details that are going um, to make it all go astray. So yeah, having as much as possible someone, if not in the country, because obviously you cannot always have one manager in every country, but at least closer to where who's involved in the restructuring, who's going to be able to give the tips and give the background of where we stand. I think it's important. And yeah, in terms of it goes, you said about aligning the various departments. I would say aligning at some point the various countries and to understand, to have a mapping all your obligations to try to see what the common ground and when is the common the common denominator, some where it's going to launch obligations everywhere.
Sure. Yeah, and really the key, as you mentioned, that map having thresholds, where your consultation obligations are. So really that expands beyond the Works Council. Even on individual processes in the UK and Ireland and Australia, you are required to consult with the employee if they have more than 2 years of service prior to providing termination. This is a common mistake we see with employers that they, will move to providing notice before they've gone through this consultation process, which means, sharing with them that a restructuring is happening, but, not confirming that a decision is made regarding their particular role, allowing opportunities to consider alternative options, hearing feedback before you make a final decision. Again, this can seem cumbersome on the front end, but can really, really impact you on the back end, both in terms of time and cost. Unfair dismissal can be, up to 1 year salary in the UK, for example. In other jurisdictions, it's not compensatable. It's just, rehiring the individual. And, obviously you don't want to have this role within the organization. So it will be a significant payout in terms of settlement in order to avoid reinstating them. So again, preparing the process effectively from the beginning, aligning your team and budgeting correctly can really create a well-run process that reduces cost and conflict and provides positive morale for your workforce long term. Florence, any final words before we sign off?
No, I'd say coming back to initially what we said, balancing act between involving local council too soon and too late. And too late is really a big damage. So to me, the earlier the better.
Excellent. Thank you so much for joining us. We'll be back in a few weeks with part 2, which will be geared towards global companies navigating U.S. risks. So come back. We'll have a colleague at Jackson Lewis, Jeff Brody, who runs our risk group. It will be very informative. Again, best practices, key risks to consider. Thank you for joining us.
Thank you for listening to Jackson Lewis's podcast, We Get Work. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient. We Get Work is available on Apple Podcasts and YouTube. For more information on our topics, presenters, and other Jackson Lewis resources, visit jacksonlewis.com.